hear about this fantastic verdict that they got, a little over $14 million. And it's a case that is really something for everyone. I mean, yeah, there's trucking involved, but my understanding, I'll let you all give the overview in a second, but liability was contested, causation was contested, damages was contested, there's TBI, there's PTSD, stuff we see in every case. So, it's one thing when we just got liability and the injuries are pretty much there, or it's just a causation and they admit liability. They denied every damn thing, and you had to fight tooth and nail to get what you got. So we can take, I'm really eager to hear about how you all got this to the finish line, got the result you did. So with that, if there's anything you want to tell the audience about yourself, go for it. If they read your bios online on your websites, want to make sure they knew what was accurate in the bios and what wasn't. But with that, introduce yourself and maybe do a little overview of what this case is about.
Then lead us off, man.
No, I know you're the, I'll let you go with there.
You're my senior. It's out there now. You're way older than I am.
I know. The big 4-0.
Well, I'm Stefano Portigliatti. I don't want to burn up time talking about me. There's a lot of good stuff, like Jay said, to talk about the case that I think would be helpful, that we even learn for ourselves going through that process, that have improved how we try cases, and I'm eager to share with everyone about it.
Awesome. So what we'll do real quick as a reminder, make sure to put questions in the Q&A. Don't put them in the chat. And in the chat, I'll make sure that Stefano and Dan in the chat box and to everyone types in their email addresses so everyone has it. And then Dan and Stefano and I will be looking at the Q&A as we go. But with that, fellas, why don't whoever wants to go first, just give us an overview about the case. Who's your client, what the case was about, how it came to your office, and then after that, we'll get into kind of when you got it, what you did when you got the case, investigation-wise, discovery-wise, and we'll kind of talk about, kind of work into that.
So I'll take on that part of it, just because I had the case at the beginning, well, sort of the beginning. The case came to us a little over a year after the crash had already occurred, from some attorneys down in South Florida. The crash happened here in Jacksonville. And at that point, what had happened was the client's semi broke down on the middle of 95 on a travel lane, just north of downtown Jacksonville. And after some time, no one knew exactly how long, another semi comes from behind and strikes the rear of the semi. Our client at that point was unrestrained, sitting in the sleeper berth, and was propelled forward, hits his head, has a large laceration on his head. But within 2 months of the crash, he had already had a neck fusion on LOP, letters of protection. It's like a doctor that isn't charging anyone, holding on to a settlement.
Real quick, is that discoverable in Florida? Are they allowed to learn about LOPs?
Discoverable,
yeah.
Admissible.
Yeah.
Okay.
And the client had a very good result from the surgery and was back to now driving for Uber. So that's when we got the case. And as we're getting into it, the client tells me that he's having a lot of nightmares. And that especially after he started driving for Uber, he was having a lot of issues with just emotionality, let's put it that way. And our co-counsel, who was phenomenal all along the way, maintaining that relationship with the client. They're both Cuban. The client's Cuban, my co-counsel's Cuban. He's keeping track of what's going on, and he's seeing, wow, this guy, I mean, this is no BS. This guy is really having issues, emotionally speaking. So we, let's work that up. Let's figure out what's going on. And that leads to a DTI MRI that comes back with some pretty notable abnormalities with, FA values. So he goes to see a mental health counselor, and that just keeps progressing. And then now we're realizing, okay, there's really something we need to focus attention on. And he ended up seeing the right doctors, having the right diagnostic treatment done and all that, such that we were able to document what would technically be called a mild traumatic brain injury, and which we did not shy away from. And we made sure that what we were claiming was what we had absolute right to claim and not announce more. And going back to the beginning, the issue from the defense side from the get was your guy broke down in the middle of 95. Our guy didn't see any triangles. Why did you break down? The records actually said that he was sleeping in the sleeper berth when the crash happened, or laying down in the sleeper berth. So what did you do? Break down and just go relax? There was no 911 call from him, no tow truck, no repair truck out there, nothing. So, and this is a defense firm that does a lot of trucking defense, and they've been on the defense side of a case where I was suing the broken down truck.
Sure.
So, from the get, they just had a very antagonistic.
Yeah.
position.
So let's do that. Let's kind of get into, because I mean, you've sprinkled so many peaks of interest for me that, I want to have time to get to them all. I mean, especially getting into the DTI stuff and the traumatic brain injury stuff, and where that battleground was, and how you showed that and taught that to the jury, really. But let's back it up to, you get in the case, it's got some legs on it before your firm gets brought in as co-counsel. Was it in suit when you got the case?
No.
Okay. So kind of what you, and then when, I know you initially were in it when did Dan just come in for a trial? Did you all do discovery together? But let's do the build up to trial about what investigation you had to do, liability wise, damage wise, expert stuff, because you talked about the LOP with the surgeon, where you all went from there. Let's kind of cover a bunch of that background stuff, and take maybe 30, 40 minutes to get into that. And then there's a question on the DTI cost, who did it. We'll cover all that later. Leave that question up there, Dan. We'll cover all that later, because that's a hot topic. I gave a seminar yesterday on TBI to Seminar Web and to a bunch of lawyers, and that's a topic people want to talk about. So we can cover that later. But go ahead, Dan. Stefano.
Well, yeah. So in terms of Dan ran all of the radiology in the case. So he does it brilliantly. And we have all the images, the presentations from trial we'll put up on the screen and all that for everyone to see.
Awesome.
So from an investigation standpoint, obviously, so now, right, from a trucking perspective, I need to figure out, why was that truck broken down? And it turned out to be a brake line that separated on the trailer that caused the brakes to apply and the truck to come to a halt. Typically, that means lots of warning signs leading up to that happen, or at least some visual cues as you're doing your pre-trip inspections, if you're doing your pre-trip inspections. So we had to really understand what that issue was, presented in a way that was always going to be unassailable. And that's what we did.
Well, because I mean, listen, a lot of our trucking cases, it's reconstruction type experts. Here, you're really getting to the mechanics of it, the braking issue, proper pre-trip inspection. What do you know? What shouldn't you know? So, I mean, did you have a commercial mechanic?
Yeah. So we had a reconstructionist who I had never worked with before.
He was great.
Co-counsel had hired him. His name is William Fisher. I would recommend him in any case. He is actually has a master's degree in traffic engineering, and his theory, like his thesis and papers and publications, are on brake systems. So
wow.
He was perfect. Before we even knew exactly what the issues were, he just happened to line up so well for the case. So that was a big part of it. And then obviously getting all the data, telematics, for example, we started getting telematics in the case for every vehicle we could. They fought us tooth and nail. It took months to get motions to compel heard and this and that and the other. We finally got the telematics on the defendant truck showing not even mild braking.
And what are and for some that aren't familiar with it or haven't had to get into telematics, what are telematics and what type of stuff do you expect to find?
Right. So telematic nowadays, every truck that's out there, unless they're older than 1997, has to have electronic logging devices. And these electronic logging devices that keep tracks of a truck driver's hours of service is hooked up to the ECM that transmits speed, location, so on and so forth to a device. So even if you don't get a download of the truck, you can get data from the telematic device that's putting everything up on the cloud. And typically they'll give you the hours of service, but to generate the hours of service, there's data beneath that that's being processed. And in this case, it happened to record even mild heart breaks, which are only like 5 miles per hour per second. And in this case, there wasn't even that, right? So that immediately starts adding points over on our side of the case. But I forgot exactly what we were supposed to do now. I'm sorry, Dan.
No, you're good. You're good. You were talking about the expert you had. You're starting to get telematics from all the vehicles. Sorry, I interrupted you. I just try to give some people some context. So, but you said that you're getting telematics from all the vehicles involved. It didn't even show mild braking, and you were starting to put the data from the trucks together to piece, I think, together the crash.
Yeah.
Right.
So
So
tell them also about the data you got from the highway, just the statistical data that we got about the number of vehicles traveling that area.
yeah, so our case had to be about the defense. It couldn't be about why the truck broke down, why it stopped in that lane, why he didn't move. It couldn't be about any of that. And we have a section that I kind of prepared here, which is normalizing our bad conduct, right? So from the get, my argument was it does not matter why our truck was stopped. It doesn't matter that it was a truck that it had or didn't have triangles, that it have or didn't have, because you run into stop traffic every single day and no one crashes. So our expert was able, so literally a quarter of a mile from where the crash happened, a week before or something like that, the FDOT had just run a study as to how many vehicles travel every hour. And we showed that there were at least 360 vehicles on that Sunday afternoon that traveled on that lane and came up on my stopped semi and didn't hit him. So at that point, it didn't matter why he was stopped. Whether he broke, if he ran out of gas, which is as stupid as you could be, you know, being a semi driver, you're going to come to a stop. That's a pretty stupid way to come to a stop. It doesn't matter anymore. And that was obviously very helpful. And we saw how, you know, what a difference that made in the focus groups, which is another element that we should talk about. Is
Absolutely.
we did 5 different focus groups in this case. And always, you know, learning something, going back, getting the discovery, adjusting the presentation, changing the order that we presented the evidence, what witness is going to say what in what order. We tested everything and went from 70% fault on our guide the first time we did it to 20% in the focus group and then 0 at trial.
And yeah, and we'll definitely spend a segment diving into the focus group stuff and the prep and the mindset, because there's a lot to learn from that you all did. So, you know, you got the data from the trucks, you got the FDOT stuff, Florida Department of Transportation statistic or the traffic study they did. What else really did you have to either rule out or develop on the liability side while you're still investigating before, you know, obviously well before trial, but I know at this point you're in suit getting the telematics. I assume you're in suit. And the battle to get it, did they give you the data right the first time? Did you have to subpoena it? Do you have to go to hearings? Because people need to hear, even though it should be easy to get this stuff, it's not. And what you have to go
we
through.
didn't get it from the defense. They told us that they had a completely different telematic system. They told us the wrong damn telematic system. So we're sending subpoena. They told us the wrong cell phone carrier.
Cell phone, yeah.
So we're sending subpoenas for the cell phone, subpoena for the telematics, for this, for that, and the other, and we're getting nothing. It doesn't line up. It doesn't match. Not at that time. We're like, how is there not data for this truck on this date? We know the truck was running. So come to find out through like the second deposition of the corporate representative that, oh, you know what, maybe in 2018, it wasn't this company yet. It might have been this other company. We're like, well, but it just, you know, you have to be relentless. You have to be, because the devil is going to be in those little details.
Yeah.
And they just kept popping up. Another thing that we had in our favor was that, so let me share my screen real quick so I can give a little bit of a visual. So this is 95. This is like the north boundary of downtown Jacksonville, more or less, 8th Street. Okay. This is what they're coming up toward the area of the collision where the arrow is. Our truck was stopped right under that arrow. So if we zoom in, here's our truck, our stop truck. And talking to my client, for example, he couldn't tell me how many feet he placed the triangles, which, you know, in trucking law, we know that that's a problem because they're supposed to know, and it's supposed to be a set number of feet. But right. We worked through white lines, and he testified that he went a couple white lines, put one, another white line, put another white line, put another. So we had 5 instead of 3, but they didn't go as far out as they were supposed to go. Okay. So that was another way that we battled that fault on my guy was, okay, yeah, he didn't put it all the way out. Did it matter if the defense never saw it? Doesn't matter. Right. This is what it ends up looking at.
Let me stop you for a second. Were there, I've had this argument before, there weren't triangles or whatever else. And, you know, you'd find one, despite reconstruction police, you'd only find one damn video, one photo with a corner of a triangle under a tire. And like, so like, did any of the police photos show the triangles?
So that's what I'm trying to show here. I don't know.
Okay,
if you
perfect.
See it,
I jumped ahead on you. I'm sorry. I stole your thunder. Sorry.
So we have these little orange things around the roadway, but yeah. If we go back, it didn't really totally line up because the truck was pushed so far. There's no way that there are triangles that far out from where they used to be.
Right.
But maybe, right? And what I was getting at, we were very, very fortunate that a third vehicle that was involved there with this lady named Davenport. I feel bad that she was involved, obviously, but she was a great witness.
Yeah.
And she testified that she came over that bridge alongside the tractor trailer. And she sees the triangles, it was more than 2, but she didn't know how many. And the truck that was stopped. And she's like, well, this guy's not slowing down. This guy's not slowing down. And she looks over and he's looking down. So she starts to back off and she testifies. So I started braking and praying. Wow. Yeah. Now the defense never deposed her until the eve of trial.
Wow.
And an interesting point on that too, as far as the trial, things you learn in trials of not to do. She was such a good witness on direct that it's sometimes, you know, if you're on the cross of that, you know, there may be only a few things that you can get out of that witness, but whatever they're going to say, it's going to hurt you. And here's this independent lay witness. And the defense made a classic mistake of just going after her because she was confused about the colors of the vehicles.
Yeah, she didn't know what color the truck was.
Yeah. But she was stronger on cross-examination than she was on direct.
Wow. Yeah.
Yeah. So they tried to say, now, what color was the truck next to you? Oh, I think it's red. Well, when you were deposed, you said it was blue. And what lane was the truck in? Oh, I think it was the right lane. Well, now you're saying it was on the 3rd lane. And she goes, sir, if it was blue or red or left or right, it don't really matter. That truck was stopped and your man was looking down, you know, that kind of thing where they're like, oh, thank you. That's exactly what the whole case is about.
But so let's talk about this. When did you first interview or talk to her in comparison to the focus groups?
Oh, way before. I already knew what she was going to say.
And was her information what helped you say, this will help us normalize our client's bad conduct?
That was a big part of it. That was a big part of it. The other part of it was, so without getting too far ahead, everyone, when I made the argument in the focus groups that what about the fact that vehicles come to a stop for infinite reasons, and we just have to be ready to stop for whatever that reason is. We may not know. It could be a duck. We have geese all over Jacksonville. Okay, you don't know how often on some main roadway there's a flock of geese just landing right there. And, you know, what are you going to do? You got to stop, right? So that is how we started to normalize it. And you see in the language that we used throughout trial, we never talked about my client semi or the broken down semi. It was stopped traffic or the stopped vehicle, stopped vehicle, stopped vehicle, stopped vehicle. Because that everybody runs into stopped vehicles all over the roadway all the time.
I love it. So, you know, other than these pictures on the screen, I assume not one photo of a triangle?
No. So here's what we were able to get in. Okay, so my client, when the truck breaks down, he's calling co-workers and the company to figure out what to do. And he calls this one guy, or this one guy calls him, and he says, I can't talk right now. I'm putting out triangles because my truck broke down. So we had him as a witness at trial to substantiate that theory, right? That he was out putting triangles for some time. We had
the timing too with the cell phone records from our client.
Oh, that's brilliant. That's fantastic. But I mean, you know, this stuff just doesn't, you don't just fall into this. I mean, you have to get the records, investigate, call people, interview people. I mean, just to get to this part.
We proactively went and subpoenaed my client's cell phone records and went through every single person he called and how long the calls were and what were you doing at this point and at this point and at this point. And we built a chronology from when the truck broke down until the crash based off of his cell phones, and interjected into that chronology when he called the company, what the company said, when he put out the triangles and this and that, so the jury could have a visual progression of everything.
So go ahead and take anything else on the slides you need to show right now. Yeah. So what was the timing you all were able to determine from the breakdown to when he was hit by the semi? 23
minutes.
Okay. So my question is, I'm sure you dealt with this in focus group and at trial, but you said it early on. Why didn't you call 911?
Yeah. So my client doesn't speak English.
Okay, there we go. Okay.
That was one theory.
Broken English. Yeah.
Yeah. He doesn't speak English very well. It's very limited. So the defense played up the whole, he was not qualified to be a truck driver because he could not speak enough English to communicate and report what happened.
I've chosen not to go down that path on defense truck drivers who couldn't speak English, because I figured that if they're there trying to earn a living for their family and they're working, that, you know, jurors I may not be perceived very well if I attack the defendant driver for not being able to speak English.
They stepped in it big time. They went about it all the wrong ways. To give you an example, that second witness in the entire trial, which was another truck driver that he used to work with, that called him when he was out placing triangles and talked about what a confident driver he was, what a safe driver he was, and how he put his life on the line because they were team drivers. I used to sleep while he drove. I had to trust him with my life.
Oh, wow. That's powerful. Powerful.
He had a bit of an accent, but it was more like a Miami accent. And if you're not familiar with Miami, you don't know, okay? So first question out of the defense lawyer's mouth with this lay witness, truck driver. Where are you from, sir? Or no.
Where are you born?
Where were you born, sir? And he says, no. I'm messing it up. It was like, where are you from, sir? Here. No. I mean, where were you born?
Yeah.
I was born in America. Like, what are you trying to say here? Because he looks Hispanic, all of a sudden, you know, he doesn't qualify as a witness or something? It was,
we did what last week or the week before I think it was last week, did another TLU webinar with Shimmick Lebecki, who's a lawyer down in New Orleans, and about a verdict they got. And the defense, I forgot what it was, defense lawyer did something in that case. And I think I made the comment then I'm going to make now. Sometimes the best things that happen to us in our cases at trial are the defense lawyers. They can't help themselves.
we have to concede a big chunk of our verdict to the defense.
I mean,
Yeah.
Well, I mean, you know, the verdict my partner and I got last year, a lot of it was stuff the defense did that we just sat there and go, you know,
things they do, and then seizing on it and really putting an exclamation point on it. That's the other thing too. They make these mistakes,
Yeah.
and then you got to exploit the mistakes.
Yeah.
For instance, getting back to things that you need to get, you know, one of the things Stefano was great on was also getting all the policies and procedures of the defendants. And this whole issue about, well, why did he call 911? They were very critical about that. He explained why, that he called the company. The company would then get a tow truck out there. They would handle that. Well, the defense's own policies and procedures were the same thing. It was not call 911. It was to call the company. So, you know, they
good for the goose is good for the gander.
Right? It's like same policies for you, but you're saying it's not good enough for him.
Yeah. And it's stuff like that. It's stuff like that you all can then capitalize on that makes you look like the good guys and you're being the honest and you're, you know, I mean, that's fantastic.
There were so many of those moments. Another one that Dan did. You ready? When we have our big neuroradiologist, you know, testifying about the DTIs and this and that and the other. The defense lawyer thinks he's going to be all smart, and he pulls a bunch of blog posts that talk about, you know, how you can't rely just on the DTI and that kind of thing, which we never disputed. And this is all news to us. They were supposed to disclose every bit of impeachment exhibits that they may be using. They didn't. So we're on the guy's website pulling it up, and we're like, this is good stuff. Like, if he just read the next paragraph, it'd be very good. So Dan gets up, you tell it, Dan.
Well, just get up and, you know, objectionable probably, but get up and we just go to move them into evidence.
We move the evidence, the article.
Evidence to article, and then, I don't know if they have any objection to it, but we'll move in the evidence article he was referencing on cross-examination, and they agreed.
What are they going to do, right?
Yeah, if you don't, I mean, and then it takes away. Right.
And the rest of the entire article is about how mild traumatic brain injuries can completely change someone's life.
Yeah, 100%. I love it. So you've done the investigation. You're in discovery. We talked about the telematics. You finally got that data. You subpoenaed your client's cell phone records. Did you also subpoena the defendant truck driver's records? Did you come up with anything there, use of the phone or anything?
No.
Ever get any information why he was looking down?
So it's a little scary to talk about because there's a motion for a new trial pending on this issue.
But we won't go too in depth on it. Let's just say they denied he was looking down.
They denied it, okay? And there's this lady saying he's looking down. So when I depose a truck driver, I can't remember who my company was. But, you know, ask me again later, I may get, and we're like, well, there's discovery pending. If you guys could please tell us who the carrier was. We are pretty much done with the trial. The last defense witness is the truck driver. And after he's done, a juror writes a question. Hey, the plaintiff showed us his phone records. Can we see the defendant's phone records? And the answer was, no, we don't have it. So they ask, were you on the phone? And he says, no, I wasn't. So then we start a rebuttal case off of that. Okay. And I asked, sir, I asked you who your phone company was, and you didn't have an answer for us, right? That's correct. Who's your phone company? Well, I don't know. Well, you said you're going to tell us at some point. I can't remember. Okay. Well, you said you weren't using the phone. Now I want to make sure we know that, you know, using the phone is broader than just calling somebody. You know that the law prohibits you from handling your phone. That's correct. In fact, your company's prohibited from requiring you to use your phone. That's correct. That would be illegal to use your phone. It would be illegal. Well, how were you dispatched?